Hello, everyone. I hope the new year has started well for all of you. Welcome to our first webinar of 2024 in the Canadian Trademark series. My name is Quan Lowe, and I'm a principal in the Trademarks group here at Smart & Biggar, based in our Vancouver office. I'm your moderator for today's talk, which will be presented by my colleagues, Olivier Jean Levesque, Nora Labonce, and Reagan Seidler. Today's presentation is titled Canadian Trademark Law 2023 Year in Review. Before we begin, I'd like to start with a couple of housekeeping matters. So I anticipate that our formal presentation will last for about 40 to 45 minutes today, and will be followed by an open and interactive Q&A session where we will try to address specific questions that you may have for us. You're welcome to submit questions at any time during the presentation by typing them into the Q&A panel, which can be accessed by clicking on the Q&A button at the bottom of your screen. Please do not type your questions into the chat panel. Someone almost always ends up doing that, but it's a lot easier for us if you use the Q&A panel instead, please. And we'll certainly try to address as many questions as we can today during our live session, but we do have quite a bit of content, and so for any questions we don't get to, we'll endeavor to follow up by email after the session today. Today's session will be recorded, and following the presentation, we will circulate an email with a replay link. Finally, at the end of the webinar today, a link will pop up to complete a survey. We would appreciate if you could take a few minutes to complete the survey and share with us your feedback on today's webinar, as well as any topics that you're interested in learning about from us. Finally, before we begin today's webinar, I'd like to offer a land acknowledgement. In the spirit of reconciliation, we respectfully recognize and acknowledge that the land we're meeting on and that all Canadians live on, work, and enjoy is the traditional territory of many nations. These lands are now home to many diverse First Nations, Inuit, and Métis peoples and are covered by various land treaties. Now I'll begin with a very brief introduction to Smart & Biggar. So, as many of you know, we are Canada's leading IP firm. We really know everything when it does come to IP, whether it's copyright, patents, and trademarks. Of course, our talk today is focused on trademarks, but that's definitely not the end of our strength. Extremely deep bench strength in all areas of IP and across the country. And we've been doing this for a pretty long time, over 130 years now. And we've also grown recently. We're now over 125 lawyers, patent and trademark agents, and technical consultants at the firm. And we file over 12,000 patent and trademark applications every year. Basically, if there's anything related to IP, we're able to help. And that includes litigation as well, not just prosecution matters. And with that, I will now turn it over. I'll just give a very quick introduction just to today's content. As you know, a year in review webinar. We'll be starting with some practice updates on the trademark side. And after that, we'll go through some of the important cases that were decided in 2023 and share some thoughts about those cases. Again, just a reminder, please use the Q&A panel. And with that, I'll now turn it over to Nora to begin with some practice updates.
Okay, thanks, Quan. So in the next few slides, I'll go through what we consider to be the four most notable practice updates from 2023. And I'll start off with everyone's favorite topic of increases to government fees. So next slide, thank you. Okay, so as many of you know, CIPO announced in 2023 that it would be significantly increasing most of its fees effective January 1st. Of this year, 2024. So in terms of what those fees look like, some of the most common Canadian trademark fees increased by 20 to 32%. And the chart included on the slide shows some of those increases. Now, I'm not going to go through that chart in detail, but you'll see that some of the most significant increases were to filing fees and renewal fees, both of which saw 32% increases. Excuse me. So regarding the reasoning behind the increases, CIPO has cited several contributing factors. So, for example, the office noted that it actually hasn't undertaken a full fee review or substantially adjusted its fees in about 20 years. And since then, there's been almost 30% inflation, which together with other factors, has put the office in a critical financial position. It's also believed that the fee increases will go, at least in part, to hiring and training new examiners. So, in that regard, SIPO shared with us that it hired over 100 new examiners, which doubled its staff. Now, naturally, it's going to take some time for those examiners to be fully trained. But once that happens, the hope is that SIPO's backlog and the delays in examination are going to be reduced. So, unfortunately, the current delay from filing to examination is over 4 years for nationally filed applications that include any goods or services that aren't taken from the Goods and Services Manual, which is maintained by the office. And so SIPO is hoping to substantially reduce that time frame. Next slide, please. Okay, so in 2023, SIPO also announced that the benchmark and cooling off extensions of time that are available in oppositions and Section 45 proceedings would be significantly reduced starting December 1st, 2023. So, just to give a little bit of context, there are various types of extensions that can be requested by parties during the course of oppositions and Section 45s. One of those is a benchmark extension. So, with respect to oppositions, benchmark extensions are available to each party at all stages up to and including when written representations are due. The length of the extension that's available depends on the particular stage of the proceeding. Some benchmark extensions require consent, others do not. As for Section 45 proceedings, a benchmark is only available to extend the registered owner's deadline to file evidence. They're not available at any other stage of the proceedings. The second type, which is on the screen, is an extension of time based on cooling off. So, in oppositions, each party can request one cooling off extension with the other's consent at any stage up to and including when written reps are due, provided that the parties are discussing settlement. Notably, there's no cooling off extension available for Section 45s. Next slide, please. Okay, so this somewhat scary looking slide provides a chart showing the impact of the reductions to the benchmark and cooling off extensions that are available during oppositions. I'm not going to go through this chart in detail either, but it's worth noting that the reductions to extensions range anywhere from 20 to 75% at different stages. So, just by way of example, the benchmark extension to file the statement of opposition, which is the first entry there, has been reduced from 4 to 2 months. You'll also note that the cooling off extension, which is the last entry, has been reduced from 9 to 7 months. Now, there's no chart showing the reductions to extensions in Section 45s because only one extension was impacted, and that's the benchmark extension to file the registered owner's evidence. So, prior to December 1, the registered owner could request a 4 month extension. As of December 1st, that extension's been reduced to 2 months. So I think the takeaway here is that the parties need to be prepared to act more quickly at all stages of oppositions in Section 45s. Okay, next slide, please. Okay, so the last couple of updates are on the tech side, and they were arguably much needed. So, first, in 2023, SIPO began sending correspondence electronically. So, trademark agents and brand owners were given the option to select email as their preferred way of receiving correspondence from the office, and that's during prosecution, oppositions, as well as Section 45s. It's worth mentioning that you need to opt in to receive email correspondence from SIPO. So if you just don't do anything, then you're going to keep getting paper correspondence from SIPO in the mail. The second update is the launch of the Trademark Document Retrieval System, or TDRS. So the TDRS can be used to retrieve electronic copies of documents filed with and issued from SIPO in respective applications and registrations, and that's including during oppositions in Section 45s. In my view, this is an exciting development because previously, if you wanted a copy of any of these documents and you weren't the agent of record or the brand owner, you would need to order a copy from the office. Now, anyone can access those documents through the TDRS by just searching for the particular application or registration that they're interested in on SIPO's database. And so, to give you an example, um, if you search for the registered trademark Smart and Bigger on SIPO's online database, and then there should be a link on the database that says View Documents. So if you click it, you'll see the what looks like on the left side of the screen there, which is the TDRS. Um, and so listed kind of halfway down the screen, you'll see the Documents tab, and that's where the documents are that the office has on file in respect of the registration. So you'll see that you can download anything issued from SIPO, anything filed with SIPO. And if you look at the bottom of the screen, you'll see it says oppositions in Section 45. So if there were any of those types of proceedings with respect to the application or registration, that's where they would show up. For the Smart Biggar registration, there was none of them, so there's nothing to select. But just to show you what it looks like, I did a search for an application that has a pending opposition proceeding, and that's on the right side. Um, so that's what the TDRS would look like for that application. You'll see there's one pending opposition at the top. And then again, halfway down, you'll see all the documents. You can access anything filed by the parties, like the evidence or the statement of opposition. You can also access anything issued from SIPO, like extensions of time and that sort of thing. Okay, next slide. Okay, so that's it for me. And with that, I'll turn it over to Olivier.
Thanks, Nora. So this first decision, yeah, thank you, which is actually one of the first decisions of 2023, is quite a fascinating decision, at least if you're trademarks geek like us, which addresses the concept of co-branding. So co-branding is obviously nothing new in trademarks law. Here on the screen, we have two examples. One is Kellogg's and Special K, which is quite a straightforward case of co-branding that courts like to use because it's straightforward because both trademarks are owned by the same entity, Kellogg's and Special K. On the right, we have another example, maybe a bit less straightforward, Puma and Gore-Tex. And I say a bit less straightforward because the trademarks are owned by different entities and point to different aspects of the same product, right? We can change slides. And now the GNR case that we're talking about today concerns another specific and quite interesting type of co-branding. That is when a retailer or distributor decides to put its trademarks on the goods that it sells, but that are manufactured by a third party. And I say it raises an interesting question because, can the retailer, in this case GNR, who essentially just provides retail services and doesn't manufacture any goods, get a trademark registration in association with the products that it sells but does not manufacture? So in this case, GNR, a retailer of RVs, recreational vehicles, tried to obtain a trademark registration in association with both recreational vehicles and dealership or retail services for these RVs. The application was opposed by another major RV retailer, CWI, on the basis that GNR had not used the trademark as of the claim dates of first use. The opposition board found that GNR established that it had used the trademark in association with the goods, but not in association with the services. The decision was eventually appealed to the federal court, and just give me a second. So the court essentially sided with the opposition board. With respect to the goods, the court found that while GNR is not the original manufacturer of the goods, the presence of stickers with the trademark affixed to the goods before the sale was sufficient to establish trademark's use in association with the goods. Oh, apologies. With respect to the services, GNR was not able to convince, somewhat ironically, right, because it offers retail services, was not able to convince the court that it had used the trademark in association with retail services for technicality, which we don't need to get into. But I wanted to show you this nugget, which I found in the decision, which says that given that the services provided by GNR were services that could be expected to be provided online, the opposition board made no error in relying on the archived web pages from the Wayback Machine. And I say it's a nugget because we've all been in a situation where we had to establish that another party had not used a trademark. And obviously, it's always been more complicated to show that a party has not used a trademark as opposed to establish use of a trademark, right? How do you show something that doesn't exist? And I think this is a good example of a case where you see that the services could be expected to be provided online, but the opponent was correct in using excerpts from Wayback Machine, which provides archived web pages to establish that the trademark had not been used. And so the key takeaways, if we go on the second slide, the first one is that according to this decision, a retailer or distributor can claim to use a trademark with goods that are manufactured by a third party. So the decision is under appeal, so we'll see what happens. But it's quite an interesting take because it suggests that the products would have two different sources, right? The one source obviously is the manufacturer of the product, and the other source is in this case the retailer. So interesting decision. We'll see what happens. Second interesting takeaway is the difference that the court made between permanent and non-permanent placement of the trademarks. And I say it's interesting because in this case, the court considered that GNR had used its trademark in association with the products because it affixed its trademarks on the products through stickers. And the court essentially said that the decision would have been very different if the trademark had not been permanently affixed on the goods, for example, if it had been on a hand tag or something like that. So an interesting decision. We'll see what happens in the appeal, and hopefully we'll have an update during next year's trademark hearing review. Change slides, please. This next decision, also quite interesting decision from the federal court, which addresses the question of confusion between foreign language character trademarks. So Chung Bakery, the applicant in this case, has operated a bakery in the Vancouver area for about 50 years, offering bakery products and related services in association with the Chinese characters trademarks that you see on the screen. The respondent, Easy Win, can change slides, please, is part of a larger group of company called Saint Honoré, which also sells bakery-related food products, including in Canada. Now, unbeknownst to Chung Bakery, Easy Win obtained trademark registrations in Canada for two trademarks, which you see on the screen, which comprise two Chinese characters that were also present in Chung's trademarks. And if you look on the screen, it's the last two characters of both trademarks, which translate into Anna, and also transliterate. So if you look at the sounds, it also transliterates into Anna as well. We can change slides, please. Now, Chung Bakery brought an application against Easy Win, seeking to expunge the Easy Win marks on the grounds of trademark confusion and bad faith. On the issue of confusion, the court affirmed through the evidence that the likely consumers of the parties' goods and services, namely the Chinese Canadian community, would be able to read and understand the Chinese characters. And therefore, rather than seeing the parties as Chinese marks simply as design marks, the way I would have seen them, the relevant consumer, the Chinese Canadian community, would understand their meanings. And based on that, the court found that the parties' trademarks were similar in appearance, sound, and ideas suggested. On the issue of bad faith, the court took note of the fact that parties had been involved in a previous trademark dispute, which actually concerned the two same characters. And so at the time of filing, Easy Win was aware of this, could not have been satisfied that it was entitled to register these in Easy Win marks. And so Chung Bakeries was successful on this ground as well. And in terms of key takeaways, I think the main takeaway is the importance of identifying the relevant consumer. And I say it's the main takeaway because the decision could have been very different if the court had decided that the relevant consumer was someone like me who doesn't understand Chinese characters, cannot read them, and would have looked at both marks simply as design marks, right? In this case, it was specifically because the court concluded that the relevant consumer was the Chinese community who was able to read these characters and understand their meaning. that it was able to conclude that there was a likelihood of confusion. So yeah, again, the importance of identifying the relevant consumer, especially in cases of involving foreign character trademarks. So Chong Bakery, the applicant in this case, was successfully represented by Smart and Biggar, including by our moderator today. This next decision, Milano Pizza, is not exactly a groundbreaking decision. It's actually quite a very short decision of the Federal Court of Appeal, but still a good reminder of the do's and don'ts of trademark licensing. So the plaintiff in this case, Milano Pizza, was the owner of a registered trademark, Milano Pizzeria and Design, which it licensed to a number of independently owned pizzerias in Canada. I believe about 40, so not a negligible number. One former licensee continued to use the Milano Pizzeria trademark after the expiration of a license agreement between them. And so, unsurprisingly, Milano Pizza brought an action for trademark infringement, passing off, and depreciation of goodwill. The former licensee counterclaimed for expungement of the registration for non-distinctiveness. And because of that, the main issue before the court was whether Milano Pizza, so the plaintiff in this case, had exercised sufficient control over the use of the trademark by its licensees, again, about 40 licensees, to maintain the distinctiveness of the trademark. Milano argued that they had exercised control over their licensees through two requirements in the license agreements. One, that the licensees had to purchase their ingredients from authorized distributors. And second, that the licensor, so Milano Pizza, agreed that no other license would be granted for the licensee's territory. So both the federal court and the Federal Court of Appeal found that Milano Pizza failed to demonstrate sufficient control over its licensees for the licensee's use of the mark to be deemed use by the trademark owner pursuant to the Trademarks Act. So because of this controlled licensing, it rendered the trademark non-distinctive because the trademark pointed to different sources, right? The trademark owner and the licensees. And so the registration was expunged. And I wanted to show you these I call them nuggets, but the good parts of the decision. It would make a mockery of section 15.1, which is the section of the Trademarks Act, which addresses licenses, if any type or degree of control was acceptable. Control over the finished product or service is therefore required. And so if you go to the next slide for the key takeaways, I think this decision is a very good reminder of the do's and don'ts of licensing. First, I think it's essential to give public notice of the license because it creates a presumption that the use of the trademark is made under license and that the owner has exercised the necessary control. And by public notice, it can simply be a small notice that you see on the back of a packaging, which says, trademark owned by that entity used under license. Then have a written trademark license agreement in place. In the case of Milano Pizza, in some cases there was a written agreement, in some cases was an oral agreement. I think there was a whole dispute about some license agreements being lost in a fire or flood. So that really complicated Milano Pizza's job of demonstrating the existence of a license and the existence of control, right? So I think it's an easy fix. Again, the interesting passage of the decision. This case can be characterized as a cautionary tale regarding the difficulties of proving, with the passage of time, both the subsistence and the terms of an oral license agreement. So an easy fix, have a written license agreement in place. And then finally, and I think it's one of the key takeaways of the decision, exercise control over the finished products or services. In this case, the court pointed to the fact that the control was provided in the license agreement, but that there was no control over the finished product, the pizza, by the licensor over the licensees. And I think that was one of the main reasons why the trademark registration was expunged. You just it's winter. Thank you. So this next case involves two major players that you're going to recognize in the battery industry, so Energizer and Duracell, so two big competitors. The plaintiff in this case is Energizer, who's the owner of various trademarks, which I'm sure you'll be aware of them, which include Energizer, Energizer Max, and then two rabbit designs that you see on the screen. And a few years ago, Duracell, so the competitor, started a comparative advertising campaign by selling batteries and packages bearing stickers with various performance claims, which we can see on the next screen, please. Which compared the longevity of Duracell's batteries to those of Energizer. So we see on the screen, and then I'd like you to take some time to look at the claims, because it's going to explain the decision of the court. So in some cases, you have the trademark of Energizer, which is very clear, very obvious. So for example, on the bottom left, you see up to 15% longer lasting versus Energizer Max. And on some other cases, it's way more subtle, right? So 20% longer lasting than the body brand, or 15% longer lasting than the next leading competitive brand. And so Energizer filed an action for depreciation of goodwill, which is similar to the cause of action for, I think, dilution in the US, and I think in Europe, which requires both use of the trademark, goodwill in that trademark, a linkage between the use of the trademark by the defendant and damages. And so the court ruled, if we change slides, that Duracell's use of Energizer's registered trademarks, Energizer and Energizer Max, contravene Section 22, but dismissed the remainder of the action with respect to the use of the expression the body brand and the next leading competitive brand, on the basis essentially that the evidence did not establish the linkage, right, between Duracell's use of the phrase the body brand and the next leading competitive brand and Energizer's trademarks. And in reaching this conclusion, the court gave specific emphasis, if we can change slides, please, to the context, placement, and size of the mark in relation to the surrounding indicia on the packaging, right? And I think this provides a useful guidance to brand owners on how to engage in comparative advertising, right? So in this case, the court did not say that the body brand was not a reference to Energizer, or that the next leading competitive brand was not a reference also to Energizer, but simply that because the way it was on the packaging in small characters, that consumers would, probably buy the batteries, somewhat in a hurry without necessarily making the linkage between Duracell's use of the body brand and next leading competitive brand phrases and Energizer's trademarks. Because this linkage could not be established, Energizer could not be successful for these two trademarks. But overall, Energizer was quite successful again, because it succeeded for Energizer and Energizer Max. But still an interesting take. And I think another interesting nugget is the courts, I think, suggested or somewhat increased the prohibitive scope of Section 22. The court said that the intent of this disposition, which is the prohibition for depreciation of goodwill, prohibits a competitor's use of a registered trademark for the purpose of appealing to the owner's customers in an effort to weaken their habit of buying what they have bought before, which essentially suggests that establishing evidence that consumers are changing their buying habits as a result of a comparative advertising campaign is sufficient to establish damages for depreciation of goodwill. So again, quite an interesting decision, and yeah, I think the next decision is for my colleague Regan.
Thanks so much, Olivier. Thanks to everyone who's joined us today for sticking with us. We have two more cases to talk about before we round out our year in review. As a reminder, if you are collecting CPD hours, make sure to record this in your own accounting of your education. The next two cases we're going to talk about both concern trademark applications, which mean attempts by a business to register and gain exclusive rights over a particular trademark. And in both cases, they got some pushback in that effort. The first case we're going to talk about come from two companies you're probably familiar with, being Puma, the clothing company, and Caterpillar. In this case, it begins with an attempt by Puma to register the word ProCat, which ended up being opposed by Caterpillar in a contested proceeding based on their rights in the word cat. So we are talking about, at the core of it, whether there is a risk of confusion between ProCat and cat. Now, in that context, you might be asking, why are we looking at a picture of current day Leo Sayer? The reason is because I'm working with public domain art, and the significance of this particular fellow is that he happens to be wearing a hat and shoes, and so I point this out merely to tell you this opposition is about using the word ProCat and the word cat as it concerns hats and shoes. So keep that in the back of your mind. We're fighting in essentially the apparel industry, broadly defined. So when this decision was first rendered, it went, of course, to the Trademarks Office. The Trademarks Office looked at ProCat and they looked at cat and they said, you know what, the only common element here is the word cat. In terms of the apparel, headwear, footwear industry, there's going to be lots of cats out there in the marketplace. So in that context, we don't think ProCat and cat are particularly similar enough that there's a problem. So the Trademarks Office would have allowed Puma's application. That gets appealed and then appealed again. So what we're talking about today is really the decision that went up to the Federal Court of Appeal. So to change the dynamic, so remembering that Caterpillar was unsuccessful in their opposition at first instance, they produced new evidence and they brought this evidence to the court's attention, and the court ends up finding differently. So at the end of the story, Caterpillar ends up being the successful party. What we're going to talk about today is how Caterpillar managed to change the opinion of the court as against the Trademarks Office based on really high quality, powerful evidence. So what did Caterpillar do to change the mind of the court? Number one, they brought in dictionary definitions. And what the dictionary definitions was for the word pro. So they came to the court and they said, the word pro is really a prefix and it means professional. So if you start looking at pro as being a prefix, it does change the dynamic of the situation a little bit, because now it almost appears as if ProCat is an extension of the cat line. You might see a similar kind of thing when you see trademark applications in the apparel space that might have the word junior in them. You might think, oh, that's just a kid's line of the main trademark, something like that. So Caterpillar's job here and the position they took was to say, look, ProCat is a prefix. Don't focus on pro, just focus on the cat. So how did Puma respond? They said, you know what? We've actually used the ProCat trademark quite a lot. So they produced evidence of their sales, showing that, or the purpose of that being to say that consumers would recognize ProCat in its entirety as the trademark. Now, the problem that Puma found was that most of its use was really not with clothing or with headwear and footwear and so on. It was with items like soccer balls, water bottles, that kind of equipment. So the court then looked at this and they said, no. The fact that you have used the ProCat trademark with goods like soccer balls doesn't actually mean consumers are going to recognize ProCat in its entirety as a trademark. So the court said, okay, I side with Caterpillar on this. I consider pro to be just a prefix. So if you look at that kind of perspective, we're now in a situation where it's a cat fight. It's cat versus cat because the emphasis is no longer on pro. Then it becomes a question of whose trademark essentially is more distinctive, how much protection is Caterpillar's cat trademark owed. Caterpillar in this case, again, had fantastic evidence. They said, we've got lots of sales. Consumers are aware of the cat trademark. We are owed a certain amount of protection from the court because this is a well-known trademark. And the court agreed with that. In response, Puma tried to do the same thing. And they said, you know what? We use all kinds of cat trademarks Now, ProCat is one of them, but there's all kinds of these other blank cat trademarks, which means effectively when consumers see ProCat, they're going to think about us. But the court here was very insightful, in fact. And what they noticed was, if you're familiar with the Puma line, they often use their trademark along with the image of that jumping black jaguar or whatever picture it happens to be. This is my public domain reproduction of the Puma trademark. And so what the court ended up saying was, maybe you do use a lot of blank cat trademarks out there, but what consumers really recognize is your logo. It's that jumping cat design. So when you balance those two, they said, you know what, Caterpillar has persuaded us. They've got a lot of sales. This is a very well-known trademark. They are owed a significant ambit of protection. And eventually the court said, no, yeah, this is unsuccessful. We think there is a risk of confusion. Caterpillar has the right to block this trademark application, and they sided with Caterpillar. So the lesson here being significant evidence or providing the right evidence to the court can have a significant effect. Oftentimes, we tell our clients, it's going to take some effort to pull your sales numbers, to find examples of how you're using the trademark, but it's really worthwhile if you can get that evidence in. And this is a case study in showing just how persuasive good evidence can be, and the fact that it is really quality evidence. It is about focusing on what do consumers actually remember about a trademark versus just, putting in evidence for the sake of it. So focus your evidence when you're putting that evidence in on what is actually in the mind of consumers, and convince the court or the trademarks office that consumers will recognize your brand for what it is. Second situation we're facing is the case of tribal chocolate versus tribal. So in this case, there was an application to register the word tribal chocolate. It was being held up not in a contested opposition, but by the trademarks office itself, who said, this tribal chocolate trademark is just a little bit too close to a registered trademark that already exists for tribal. They said tribal versus tribal chocolate, too close, consumers are going to be confused. Again, you're asking, why are we looking at this fellow in the bathtub? It's because this application is existing in the field of hair care. So theoretically, this guy is shampooing himself or something. Again, I'm working with public domain art. I think it's pretty good. Just remember, we're existing, both of these companies exist in the field of hair care. The significant thing about this case is that the two parties actually didn't have a problem with each other. And this is a common situation we see all the time. Often cases, if there is going to be an application or another trademark in the market or on the register that's blocking one owned by a business, the two companies know about each other because they've coexisted in the States or Europe or elsewhere. So in this case, they didn't actually think there was going to be a practical problem. Nonetheless, they had to convince the trademarks office there wasn't a problem, and that's a separate statutory administrative issue. So the parties in this case actually had an agreement that they'd entered into that said, we are fine coexisting with one another. We are fine if the tribal chocolate application goes through and gets registered. It's not a commercial problem for us from the marketplace. And as part of that coexistence agreement, they had agreed to certain terms between them on a contractual basis to reduce the risk that consumers would, from a practical perspective, be confused. Now, you don't have to read all the terms on the screen. The significant parts were maybe three. On the first point, the applicant here, Tweak D, said that it would sell its goods to mass market retailers, drugstores, open shopping channels, internet retailers, but they were going to leave beauty salons and spas alone. And within the hair care market, you can understand there is somewhat of a divergence between brands that sell themselves through salons and those that are in just major retailers. So they committed to that contractually. They also committed that neither party would change the way their trademark was actually depicted in terms of their branding. That obviously goes a long way when you're just thinking about how consumers react to seeing products on the shelf. And they also said that neither party would promote its goods. This is a higher level restriction, but they said they wouldn't promote their goods in such a way as to cause confusion. So practically speaking, these are pretty sensible terms to include in a trademark coexistence agreement. If it was following litigation, this would be quite sensible. The problem is we're not dealing with a fight between two parties. What we're looking at in this context is trying to convince the Trademarks Office that there's no risk of confusion. So they filed this agreement with the Trademarks Office, and the Trademarks Office said, no, I'm sorry, that's not enough. And this is a pattern that we see quite often. When the Trademarks Office looked at this, they said, we have a statutory duty to ensure that no trademark gets registered if it's confusing with another one on the register. We appreciate you have an agreement between you two, but that's primarily contractual. It doesn't change our perspective that the two trademarks are too similar. And it shows, and this is surprising for a lot of counsel we deal with that work in other jurisdictions, but the Trademarks Office does not put a significant amount of weight on the mere fact that parties are okay coexisting with their respective trademarks. So even though it may not be a practical problem for consumers in the marketplace, it's often not enough to convince the Trademarks Office to withdraw a confusion objection. And that's, that can be a tough thing for a business owner to understand, but it is the reality. So they appealed this to the court. The court said, no, look, I agree with the Trademarks Office. This is how they viewed it. I don't see that as an error. Again, the council appealed it to the Federal Court of Appeal. Federal Court of Appeal said the same thing. They didn't disagree with the federal court or the Trademarks Office, and they said, look, this was viewed as contractual terms between the parties, doesn't change the registrar's job. There is a rule that prevents them from registering trademarks if they're too similar to one another. So the trademark application was refused. The fact that they had this agreement didn't get around the fundamental problem that the trademarks in their view were too close. So where does this leave us? I think the takeaway here or the lesson that we're all aware of is that a mere consent agreement is not enough to get a trademark registered. Now, that's not to say that they're meaningless. And the real lesson that experienced practitioners know is that if you're going to write a trademark agreement specifically for the purpose of convincing the Trademarks Office to withdraw a confusion objection, what you need to focus that agreement on are the reasons that there is no confusion in the marketplace. So agreeing, as we saw, to brand in different ways is not going to convince them, perhaps. But what would be convincing is evidence if you, for instance, recorded in the agreement, we have both been selling our goods in the States for 20 years. We've never heard of consumers being confused. And if there was going to be confusion, we would know because we have, I don't know, a call center that talks to consumers every day. That would be a fact that you could record in a trademark agreement that the Trademarks Office would look at and say, okay, that is an interesting fact I didn't have before. Maybe that causes me to change my perspective. So there are ways of constructing these agreements to put facts before the registrar that can convince them to withdraw their confusion objections, but merely relying on the fact that there's consent or contractual protections between the parties, likely not going to be enough to convince the Trademarks Office to withdraw a confusion objection if they are concerned that the trademarks are too similar. That is our summary of our 6 cases again today. If you have questions you would like answered, we have a little bit of time still with you. We'd be happy to chat. I can bring in my other colleagues if they want to contribute. Otherwise, of course, we are very happy to have you join us and hope that you will stick around for webinars in the future. And Quan, I believe we do have a webinar coming up again soon. Is that right?
Thanks, Reagan. Yeah, that's right. And I'll get to that just as we conclude, but certainly want to leave some time for Q&A today. So we'll take a look at some of the questions that have come in. As a reminder, you can submit your questions to the Q&A panel by clicking on the button at the bottom of your screen. So I'll begin with the first question we have today, and I think this one should be for Olivier. So the first question we have here is, do you have any expectations for the Federal Court of Appeal appeal of the GNR decision?
It's actually a good question. Regan, can you come back to, I think it's slides 6 or 7, I'm not sure. Yeah, just after. Next one. So again, that's my personal opinion and not the opinion of the firm, and we're not involved, to my knowledge, in that case. I tend to agree with the position advanced by CWI, which is shown on the screen, and I'll read it to you. The position advanced by CWI appears to be that only an original manufacturer of a good can show use of a trademark affixed to those goods, while all others in the supply chain are merely providing a service, and any trademark that they affix to those goods thereby becomes associated with only that services. And I say that because use according to the Trademarks Act is two things, right? It's use according to Section 4, and I'm going to try not to get in the technicalities too much, but use according to Section 4, which is it has to be affixed on the product, right? And then use according to Section 2, which is it has to be an identifier of source, right? It has to point to a single source. And I think in this case, so GNR was able to establish that its trademark was affixed to the goods, and we mentioned it. I think the court took a lot of note of the fact that its trademark was permanently affixed to the RVs, but did not really consider whether or not the trademark was an identifier of source. And I think it's a weird concept to say that the product now, so the RV, because it has two trademarks, now it has two different sources, right? So GNR is only a retailer, doesn't manufacture anything. Consumers, when they see the trademark, in my opinion, they know it refers to the retail services and not to the goods. So I think it's going to be interesting to see how it's going to unfold, because it has some consequences, right? If you're a big retailer, if you're a major retail store, and you sell, anything from clothes to, I don't know, suitcases to, think of any big department store. Then technically, as long as that department store affixes a sticker to the goods that it sells, that would be used in association with all of those products, and it could get a registration with, a big list of products. So in my opinion, that doesn't make a lot of sense. But again, I'm not. That's just my personal opinion. I'm sure I didn't consider the question as much as the court. So yeah.
Thanks, Olivier. All right, we've got a few more questions coming in. The next one, I think, Reagan, is for you. So the question is, can you talk a little about the standard of review issue in the Tweak D case?
I can't believe someone wants me to talk about this. I am so hyped up about the standard of review issue. I know nobody agrees with me. So typically when the Trademarks Office has made a decision, those decisions are reviewed by the court using appellate standards, because there's a statutory right of appeal. So that means correctness on questions of law, otherwise palpable of an overriding error. But you'll remember that I think it was last year, 2022, in the SOCAN and ESA decision, Supreme Court created a new category for correctness review as it concerns, primarily judicial reviews. And that was when courts and administrative decision makers have concurrent first instance jurisdiction. So when they have both been empowered by Parliament to answer a particular legal question, they've said that's a time when it would be appropriate for a court to look at a question from a correctness point of view. The appellants, when Tweak D wanted the registrar's decision reviewed, said you should take a correctness view of this appeal, because in their view, the court had concurrent first instance jurisdiction with the Trademarks Office. The court said no. So the court reviewed it based on standard appellate standards. So that would be palpable and overriding error. On the basis, and their justification was that the court didn't have first instance jurisdiction to decide whether a trademark should be registered or not. They were acting purely in an appellate capacity. There was a statutory right of appeal, as I said. There's been some discussion about whether that was correct or not. Now, the Federal Court of Appeal agreed. They're, of course, excellent at administrative law questions. But the question would come down to, does the court have first instance jurisdiction over the legal question of confusion? And that was at play fundamentally in the Tweak D decision. The Federal Court of Appeal said no, this was all handled correctly. It should remain palpable and overriding error. But it would be interesting the next time this gets litigated to put to the court, maybe you do have first instance jurisdiction over questions of confusion. Now, that might be putting it too simply because, of course, confusion in the context of a trademark application is different given the onus on the applicant versus, in a litigation kind of context where the plaintiff would have the onus to prove confusion. So it's a bit debatable, but in any event, it looks like for the near future anyway, probably the long term, it's standard appellate standards of review going forward on decisions from the registrar. And that is my summary.
Thanks very much, Reagan. We've got a few minutes left, a few questions. We'll try to get to both of these. Olivier, I think this is back to you. The question is, can you comment on use of competitors' marks in comparative advertising of services?
It's a good question. I'm not an expert on comparative advertising specifically. There's good case law in Canada regarding that. I think the Clairol decision, which is discussed at length in Energizer, is quite interesting on that. My understanding of the position of the courts in Canada on that is that it's not use of a trademark for comparative purposes in a comparative advertisement is not an infringement of trademark per se. But again, as we see in Energizer, everything is just a question of context. How does it happens in practice, right? So I think it's really case by case basis.
Thanks, Olivier. Next question, I think, Reagan, is back to you. In regards to consent not being a valuable argument to avoid confusion, how would you draft an agreement to make the registrar think there is no confusion? Would you add marketplace investigations as an annex or schedule? Would you add consumer surveys?
Fair. Surveys and marketplace investigations could be given to the registrar at any time. I don't think you need a coexistence agreement necessarily to do that. The key takeaway from this case is that, remember, when the Trademarks Office is considering if two marks are confusing, they have really very little context to make that decision. It's not like a court where they have evidence of how the marks are being used in the marketplace and the channels of trade. It's really a paper-based analysis of, are these trademarks the same and are the goods the same? So if you are preparing a coexistence agreement to give to the Trademarks Office, what you want to do is essentially create an agreed statement of facts that say, these are the reasons that we don't find the marks to be confusing. So don't give them just the conclusion that there's no likelihood of confusion. Say there's no confusion because this type of steel rod is completely different from this other type of steel rod. And maybe that's not apparent to you, but in our industry, everyone would know these two types of steel rods are totally different. Or you could say, yeah, maybe these are both glasses, but these glasses are only possible to be prescribed through an ophthalmologist office. And maybe you don't know a lot about the glasses industry, but we do. And here are some facts about our industry that make it clear consumers are not going to be confused. So that should be the purpose of the coexistence agreement. If you're trying to give it to the Trademarks Office, fill it with the whereas clauses that say, here are the reasons that in practice, no one is going to be confused between our respective trademarks. So that's what you should be focusing on if the purpose of that agreement is to convince the Trademarks Office to withdraw an objection.
Great. Thanks, Reagan. So with that, we're at 9:55 a.m. for me, or 12:55 p.m. for many of you, and I think we'll start wrapping it up. We've gotten through the questions that were asked today, so that's very good. Certainly, if you have any questions, feel free to reach out to us by email. As a reminder, we ask that you please complete our survey when the link pops up at the end of the webinar. Really, any feedback is very much appreciated for us. So again, on behalf of all of our speakers today, thank you very much for taking the time with us today. And hopefully we will see you for our next webinar, which is going to be on March the 7th. And that's going to be on a very interesting topic, and that is risks and rewards with AI in marketing and advertising. Thank you again, and see you soon.